Thank you all for joining us this morning for this introduction to restructuring from us here at Radcliffe Chambers. I'm James Fagan. I'm joined by Lauren Kreamer. So today, what we're going to be bringing you through are CVAs, administration, liquidation, Lpa Receivership, administrative receivership, dissolution, schemes of arrangement, CIGA Restructuring Plans, and CIGA Moratorium. So a full schedule to get through in the next hour. You will be able to ask questions through the Q&A box, which should be available on your screen. So we hope to be able to answer your questions at the end of the presentation. So that without much further ado, I'd like to hand you over to Lauren.
Thanks, James. I'll kick off. We're going to take it in turns so you don't get too bored hearing each one of us go on for too long. So I'll start off with CVAs. I think these are probably the most common thing you'll be asked about by clients in the corporate restructuring sphere. Of course, CVA is a company voluntary arrangement. There's some overview details here, and these slides will be circulated, so I've included the detail. But essentially, it's a procedure that permits a company to come to an agreement or an arrangement with its creditors to repay its debts or indeed a part of its debts. And I'll come on to the pros and cons, but again, it's one of the reasons that it will be one of the more common things you'll come across, because it's flexible and it allows a proposal, tailor-made proposal, to be made by the company, which has obvious advantages. So the company makes that proposal and then the creditors vote on it. Now, it doesn't require unanimity, rather it needs 75% of creditors at least by value to vote in favour of a proposal for it to be passed, and also 50% by value of unconnected creditors. So you've got an additional protective measure for creditors there to prevent, for instance, a debt becoming owed conveniently to a connected entity, such that it can vote through the proposal, which is in the company's best interest. And it's implemented under the supervision of an IP and is an insolvency procedure governed by the Insolvency Act. It binds all unsecured creditors who were entitled to vote at the meeting. That's whether they actually voted or not. And indeed, as I say, even if you're in that dissenting minority, it binds you as well. But it doesn't bind secured or preferential creditors unless they expressly consent. And it's not uncommon for an arrangement to be reached with the secured creditors alongside a CVA, but it's not a given and won't necessarily be the case unless you get that separate agreement. Another thing to note about CVAs is they don't include a statutory moratorium. You can have a 28-day moratorium in place where it's a small company and there are specified requirements for that to be the case. Now, you probably mostly won't come across that in the kinds of clients you're going to be dealing with. But there are, for instance, if you have under a certain turnover and a certain number of employees, you can avail yourself of that moratorium. In practice, and we'll come on to it, but at the moment, I think people are probably more likely to go with the CIGA moratorium anyway, if they want to avail themselves of a moratorium. As I say, we'll come on to that. So what are the pros? As I've said, they're very flexible. You can essentially propose what you like, subject, of course, to the caveat that it's got to be something that enough of your creditors also like. The company doesn't need to be insolvent when it proposes the CVA, and it's relatively informal, so there's no court involvement unless there's a challenge, though it does need an IP supervising it. Massive advantage is that it can bind a dissenting minority, so you don't need universal approval. So if you have some difficult creditors will never go for anything you're proposing other than full repayment, then it's helpful in that respect. And it also allows the directors to kind of maintain some control going through the process, and then hopefully and ideally to end up in a strong position once the CVA's been completed. You can also use it alongside an admin, and that then does give you the benefit of the statutory moratorium. Why not? The first point there is the obvious one, but staggeringly few clients think about this before proposing a CVA. I think probably because they've heard about them and think that they're a great way of getting out of their debts without thinking about whether their creditors are going to go for what they're proposing. The statutory moratorium point is an important one and definitely worthy of consideration if you've got threats of other enforcement action from creditors. It's not binding on your secureds and your preferentials, so unless they're consenting, it's unlikely to be convenient or appropriate for more complex corporate structures where there's considerable amounts of secured lending. Worth bearing in mind, as I mentioned, that it's an insolvency process. So if you've got insolvency related cross defaults in contracts, that's a massive consideration for the purposes of deciding whether to implement a CVA, as is whether you've got leasehold property in the company which may be forfeited upon an insolvency event. So important to bear in mind. We'll come on to Brexit. There's been a loss of the kind of flexibility of CVAs as well as some of the other restructuring proposals or procedures we're going to talk about. And then again, will depend on the nature of the business you're advising, but sometimes there are reputational concerns. So, you know, the recent Debenhams, Regis, New Look CVA cases have all been pretty high profile. And while landlords are not necessarily the most sympathetic of counterparties, there's still a sort of public perception of unfairness around them.
Thank you very much. Now, our second method we're considering today. Oh,
sorry. That was me.
Okay, we can bring it back. Okay. So our second method today is administration, which many of you are likely to be familiar with. That is essentially liquidation's friendly brother. The purpose of placing a company into administration is in order to attempt a reorganization of the company or to realize its assets, which in an administration compared with a liquidation can be done on a going concern basis. So the reason you'd want to do that is generally it can be seen that there might be a good business within the company that has the potential to survive. And so even if it's in trading difficulties, by entering administration, there may be a way in which that core business can be rescued, or there might be a way of just generally restructuring the organization to enable it to better manage its liabilities, or sometimes it's just better to get realizations when you can sell the company as a whole, rather than some of the assets just being stripped off individually, as can happen in a liquidation scenario. And one of the main features of administration is that it gives the company the benefit of a moratorium against creditor action. What this means in practice is that creditors and others are prohibited from taking or pursuing proceedings against the company while it is in administration. While there is an option for creditors to seek court permission to bring actions, the reality is if that is a liquidated claim against the company, a court's unlikely to grant that permission, because to do so would necessarily undermine the statutory purpose of creating that protection for the company to allow it to restructure or otherwise. The administration process is overseen by an insolvency practitioner. His powers are essentially that he can do anything necessary or expedient for the management of the affairs, business, and property of the company. So in administration, a company can continue to trade. However, he must perform his functions quickly and efficiently with regards to the interest of the creditors as a whole. In terms of starting the administration process, it can be done in court or out of court under those paragraphs in Schedule B1 to the Insolvency Act 1986. A court order of administration can be made on notice and can be applied for by creditors, the company, its directors, a liquidator, supervisors of the CVA, by the FCA under FSMA, and rarely, if ever, under the Magistrates Act on the return of a warrant for control, where it seems that the company doesn't have enough assets to meet that warrant. The out-of-court process, which you see quite a lot, can be commenced by the company by filing the necessary documents at court, or by what are known as qualifying floating charge holders. and those are floating charges that meet certain requirements set out in paragraph 14 of Schedule B1. The main sort of purpose of an administration, and what an administrator must do, is he must seek to achieve one of three statutory objectives, which exist in a hierarchy. So the first objective is to rescue the company as a going concern. So that might be achieved by way of restructuring the company's debts, or through another form of company reorganization, or the administrator must seek to obtain a better result for the creditors as a whole versus winding up the company. That might be achieved by selling the assets in part or all of the business. And again, there's more value in assets being combined together in a sale, particularly with goodwill, than simply being sold piecemeal after the company has failed. And if none of that is possible, then the administrator must look to realize assets for distribution to secured or preferential creditors. What should be noticed about administration is it's for a 12-month period, which can be extended by court order. And if the administration leads to the rescue of the company as going concern, the administrator will give up control of the company back to its directors once the administration ends. And if that doesn't happen, there's a distribution to creditors, either by the administrator or by subsequent liquidation. In terms of why it's seen as an advantageous process, it's not a single creditor controlling it. And the moratorium can be helpful in ensuring rescue plans are developed and implemented. The likely outcome is going to be better for creditors than through a classic liquidation. And the process may in fact save the business rather than through either a sale or a hive down, if not the limited company itself. So I'll hand back to Lauren to take us on.
Thank you. Liquidation, I should say as well, we'll come back to questions at the end. Liquidation, obviously not on its own a sort of self-standing restructuring process, but it typically is involved in some way, or often is involved in some way in larger corporate restructuring processes. It's worth being aware of anyway, because typically it's the comparator to any restructuring process. So what you have to show in order to get another process through effectively is, excuse me, is that you're having a better outcome. You're going to get a better outcome in whatever the alternative process is than you would in a liquidation. And I think it's also important to be aware of it, because sometimes it just is what you're going to have to tell clients that they're going to have to do. Sometimes it's not always possible to rescue a company or rescue it in the way that the clients are envisaging. And so liquidation often crops up in one of those contexts, although obviously it is not on its own a restructuring process. Also known as winding up, you will often hear it called that, same thing, subject to what I'm about to say, and is ultimately can be summarized as the realization and distribution of assets to creditors in satisfaction of secured and unsecured liabilities. Following that, the company is dissolved, so it's the end of the company. There are different kinds. So you have MVL, members voluntary liquidation, and that's by the members, happens where the company is solvent, and the directors have to declare solvency. Creditors voluntary liquidation, again by the members, but without that declaration of solvency. And then probably the one you've come across the most often, compulsory liquidation, which is the court process. That's where typically somebody petitions for the winding up of a company. And that's winding up or compulsory liquidation. A brief note that the restrictions on winding up a company imposed by CIGA are still in place, as you'll be aware. They are in place until the 30th of June. I'm reluctant to say, we're sure that it won't go any further than that, because there's been several extensions, as everyone will know. We think no further. We think it's wrapping up, but we shall have to see, and obviously policy in this regard is developing I think it's fair to say, on a daily basis. So when and why liquidate? I mean, as I say, for the most part, it's going to be the unhappy alternative. It's what your clients don't want. I think the other thing about liquidation and why it comes into the restructuring process is that very often a winding up petition, whether it's the threat of one or one being presented, is what will trigger the need for a restructuring plan, because people finally realise, people in particular who've sort of been having their heads in the sand, finally realise that no, actually something needs to be done now, although it is not ideal to wait until that stage. And as I say, it's important to understand that, and for clients to understand that it will be the alternative if whatever is proposed in the alternative doesn't succeed. So clients need to understand its consequences. It's not always doom and gloom, although often it is. In large corporate restructurings, it can be a very useful tool, and that's often the MVL kind of route. So typically where company is solvent but doesn't need to exist anymore. The business of the company, typically in that scenario, is sold often to another company within the same ownership, but it can be to a third party depending on the process and on the specific facts. And then the company is wound up after that. The disadvantages can massively outweigh the benefits, because a liquidator has to be appointed even in an MBL, and that then results in obviously the statutory investigations that the liquidator has to carry out into the company's affairs, the directors, so on and so forth, and ensuring or effectively confirming that the best outcome for creditors has been achieved. That is, as everyone will know, expensive and pretty invasive, and can result in action being taken against the directors personally. So not always right, but equally, I think probably fair to say not always wrong.
And back to me for Lpa Receiverships. If I can get this to move. There we go. So an Lpa receivership is essentially a process in which a creditor assumes ownership of a debtor's property after they default on a mortgage that is secured by a fixed legal charge. It's not a restructuring mechanism or process per se, but it is important to provide it by way of context to administrative receiverships, but also to make clients aware of the risk of receivers being appointed over their property, because that may be a factor in deciding whether to enter into another of the restructuring options that are available to them. Because at the end of the day, if a receiver is appointed over assets, it's going to make restructuring of the company much more difficult going forward. Most likely the writing's already on the wall at that stage. What effectively a receivership does is it's going to be asset stripping. A receiver will be empowered to take custody of the charged assets, manage those assets and receive the income from them. And depending on certain circumstances and the powers granted to them under the security documentation, a power to sell those assets as well. So a chargee will appoint a receiver to the assets of a charger in a private appointment made under the contractual terms of a security document. In this case, the terms of the receivership are a function of the security documentation and how they affect that appointment. In contrast, there's the older, more traditional way of doing it under the Law of Property Act, which will apply where there is a mortgage or charge created by deed over the assets of the charger. And the Law of Property Act provides then that in certain circumstances, a receiver can be appointed and will have the powers granted under that act. However, the powers under that act are quite limited, and therefore it's generally preferable for creditors to appoint receivers under express terms in security documents. Generally, standard form documents will provide for standard form powers. And the point is to note is there is no moratorium. So while directors will remain in place of the company, they will lose control over the relevant asset or assets. And it only is going to benefit the secured creditor who appoints the receiver. One point to note is that the receiver may owe duties not only to the appointing creditor, but also to the chargeor. And that arises out of the chargeor's interest in the equity of redemption in the underlying asset. And generally how that translates in practice is that the receiver is under a duty to obtain a reasonable price for the asset upon sale. But obviously, if a receiver is going to be appointed, that's a very dangerous situation for a company to find itself in. And so it's something it really should bear in mind, and whether it then wants to move into a different restructuring process to hopefully avoid those negative consequences visiting upon its business and assets. So I'll hand back to Lauren.
Thank you. Administrative receivership. I'll run through it relatively quickly because you will probably almost never see it, for the reasons I'll outline. So appointed by a creditor that holds a floating charge over all or substantially all is the test of the assets of a company. Administrative receivers similarly have very wide-ranging powers to take over the running of the company's business. So they can dispose of charged assets, they can sell the business in order to meet the secured debt. That last point is the real sort of nub of administrative receivership. Their duties, their responsibilities are to the appointing creditor, to the creditor who's appointed them. They've got to be a licensed IP. Now, as I said, much more relevant in the past than now, and actually quite a long time in the past now, I realised as I was pulling the slides together. The Enterprise Act 2002 came into force in September 2003, and effectively they've abolished administrative receiverships for the holders of floating charges. So it doesn't apply to floating charges created before it came into force. I think we're still sort of just about close enough to that it's still conceivable that you could have floating charges created before September 03, but obviously with every year that passes it becomes more unlikely and more rare. There are some limited but important exceptions, so do brush up on those if this is something that comes up in your practices. I've put the section reference in the Insolvency Act there. As you'll see, they're quite specific things, but just in case any of those ring any bells as you're thinking about administrative receivership. Pros and cons, I should say relatively early on that they're mostly cons, which is probably why the Enterprise Act effectively got rid of them. There's no statutory moratorium. The directors do remain in place kind of strangely because they are effectively replaced by the administrative receiver. The very common concern about these, which was right, was that administrative receivership would be a termination event for, as I said earlier, for a contract or a leasehold interest in a property. And for that reason, administration was often preferred to administrative receivership, because you can see that even as the creditor who wants to sort of take a hold of this and get it in shape and get paid, if the company's going to lose a major asset as a result of the process you instigate, then you're not going to instigate it. So that was a massive downside. It's essentially asset stripping, and it focuses on the appointing creditor, often to the detriment of other secured creditors, but more significantly, I suppose, unsecured creditors, because the administrative receiver doesn't have the power, even if they wanted to make a distribution to unsecured creditors. So you start to see that really it was just a way for one creditor to take a very significant level of control over a business, to the detriment of potentially numerous other creditors. Employees not affected, a small pro, and will be to transferred if the business is sold. They do have wide powers to effect a turnaround, but that frankly is a pretty optimistic way of viewing what typically happened. As I say, typically it was much more an asset stripping procedure. And as I said earlier, it was always a choice in the past between appointing administrator and administrative receiver. And for a secured creditor, I think it typically wasn't, I think, a difficult choice. But nevertheless, administrative receivership remains available in limited circumstances.
Okay, so dissolution. Obviously, where you are undertaking a corporate restructuring, one of the biggest things you may consider is tidying up your corporate group structure. And you will look to do this through dissolving dormant or unnecessary companies and essentially tidying things up. Dissolution essentially means the company no longer exists as a separate legal entity. It's the final step in getting rid of a company. It's the end of the process that begins with striking the company's name off the register of companies. So there is really, dissolution only occurs once the Gazette publishes the notification that there's been a striking off. That's the final step in deeming a company dissolved. Dissolution can occur either voluntary or involuntary. Involuntary arises where the basically the company's registrar has reasonable cause to believe a company is not carrying on business or an operation, and then uses its own powers to strike a company. You can, obviously, that is an option. You can decide to leave a company dormant and hope that eventually the registrar gets around to it. It's the cheapest way of obviously getting a company dissolved, but it may not be advisable to do so for a variety of reasons, which I'll come on to when considering what you need to think about when you want to dissolve a company. The voluntary dissolution process, it obviously can be carried out by members, the company itself, its directors. The reason why it's an important part of restructuring is it can help tidy up overly complicated group structures, because there are costs of keeping a company on the register, because for a variety of statutory obligations, the need to file accounts on a yearly basis. Further, there must be at least one natural person appointed as a director of a company, even if it's dormant under Section 155 of the Companies Act. So that's another reason why you may not want a bunch of zombie companies essentially out there doing nothing, because someone's going to have their name on documents. And as a consequence, they will always have an extant risk of liability because there are directors' duties which they have, and they don't want to inadvertently breach that. And finally, there may be a positive balance sheet impact by getting rid of older dormant companies. So when you decide to dissolve a company, one of the things you must do is ensure that you notify members, directors, creditors, and employees of the company that it's going to be dissolved, and a failure to do so will constitute an offence. So that's a very important step that shouldn't be missed off if you decide to dissolve. There are also bars to dissolving companies under the voluntary method, and they're contained in sections 1004 and 1005. So that includes if within the 3 months preceding the application to dissolve, the company changed its name, traded or carried on business, or disposed for value of property or rights which it had held for the purpose of trading, or if it engages in any activity which isn't necessary or expedient for the purpose of the application, or concluding the affairs of the company. I think it's very easy to forget that there essentially needs to be a period of dormancy before you then take the formal step. And also, an application cannot be made while there is a scheme of arrangement, restructuring plan, CVA not concluded, or if the company is in administration or a moratorium. In terms of practical things to think out, other than those statutory requirements, it's very important to know and to be sure of what assets the company does or does not have, because the consequence of dissolving a company is that can be severe, because any assets it held at the time of dissolution are deemed bona vacantia and therefore vest in the Crown, which can be a very embarrassing and expensive mistake if it turns out that your dormant company somewhere in the group actually had the benefit under a valuable contract or owned some property somewhere. You can, of course, unwind the process, but that is going to be a difficult one to have to explain to your clients. It's going to cost money, and depending on when the dissolution occurred, there's no guarantee it'll work if a sufficient period of time has elapsed. Furthermore, it's advisable to consider the mechanism for which you're going to return share capital once the company is dissolved. because there may be tax consequences to doing so. And additionally, you're going to want to make sure that the tax position of that company has been considered and sort of bottomed out before you dissolve, because there is a risk, of course, that the tax liabilities may migrate to other companies within the group. So while dissolution seems like it would normally be a very straightforward, you apply and you get rid of the company, there are some thorny points that you just need to make sure you sort of go through with the client, with the accounts, to make sure that you don't run into those nasty surprises as part of a restructuring process. So I'll hand back to Lauren.
Yeah, I actually had one of those when I was very junior. I think I might even have been a pupil, where very embarrassingly a large bank had, as part of its corporate restructuring process, dissolved a company that it later realised owned, I think, actually its main banking premises in Canary Wharf. It was certainly an extremely valuable property, and it was only sort of slightly further down the line, thankfully not too far away, that they realised that this property was now one of vacantia. So obviously it was totally fine, and we got the company back on the register, but and transferred the property out. But as James says, it's embarrassing. It's far from ideal, and it's extremely stressful to have effectively given hundreds of millions, potentially billions of pounds worth of land and property to the Crown. So schemes of arrangement. This is something that occupied a lot of my time in the course of last year, working on the Sunbird case, which was notable for having been a matter where, firstly, it was an SME. So there was some helpful guidance from Mr. Justice Snowden about how schemes apply to SMEs, and also because in the first instance, or the first scheme was not sanctioned by the court, notwithstanding that it had been approved by creditors. So that was yeah, as I say, took up a great portion of last year for me. A quick overview of schemes, because depending on the kind of clients that you advise in relation to restructuring matters, these are either going to be extremely common or not very common at all. They're a statutory process procedure under Part 26 of the Companies Act. Not Part 26A, which we'll come on to, but they are not an insolvency procedure, although there is a requirement that the company is encountering effectively financial difficulties. Similarly to a CVA, it's extremely wide-reaching and wide-ranging in its nature and its effect. You can essentially agree whatever you like with your members or creditors, subject again to them agreeing to it. But that means that it can give rise to basically any and every kind of restructuring you're after. So it's an extremely flexible and useful tool because of that. It has to be approved by the court, and as every authority on schemes makes clear, it's not just a rubber stamping exercise. And I think some people had sort of started to question that, and then Sunbird came along last year, and Mr. Justice Snowden made very clear that schemes can and will be refused sanction where, even where creditors have approved them, if the court's not satisfied that the proper processes have been followed, or that it's not in the interests of the creditors as a whole. It's a more complex process, certainly much more complex process than the CVA process. You have to make an application to court that needs to include or be accompanied by evidence and a draft, what's called a scheme circular. The court then makes an order summoning a meeting of the relevant classes of members or creditors. So you separate your creditors or your members out into classes which allow them to sort of effectively vote in the same capacity. Then an explanatory statement has to be sent to the attendees a certain period of time before the meeting, setting out exactly what you're proposing by way of your scheme. And then the meeting takes place. And typically, again, because these tend to be as part of bigger corporate structures, typically, and you have traditionally more sophisticated investor creditors rather than individuals or smaller companies. People will have considered these beforehand, will have been aware of them. And so the meeting is very often mostly taken up by the voting process. The scheme needs 50% by number of each class and 75% of total value of creditors in order to be approved by the creditors. And then, as I say, there's a further hearing, and then the court decides whether to sanction the scheme. And creditors who have opposed or objected to the scheme can attend, can make their representations, and I represented the objecting creditors or the opposing creditors in Sunbird, and we were in the group of those creditors who had been in the dissenting minority, had not voted for the scheme, and wished to oppose it at the sanction stage. So why schemes? They are, as I say, very, very flexible, and can be used to achieve pretty much any purpose you like. They're very useful, particularly in as much as, unlike CVAs, they can be used where the rights of secured creditors are also intended to be compromised. And they can also, for that reason, be tailored to different classes of creditors in a much more in-depth way than you would sometimes be able to achieve in a CVA. They are cheaper than some other insolvency processes, but certainly not cheaper than CVAs. The court process can be extremely expensive, particularly if you have opposed hearings. If it's all agreed and pretty straightforward, then it can be not rubber stamping, as the courts are very keen to remind us, but it can be a relatively straightforward process. Also useful, similarly to CVAs, in that it doesn't require universal approval, so you can bind that dissenting minority, subject, of course, as I say, to the court sanctioning the scheme. It's not an insolvency process, so unlike CVAs, I don't think you have the same sense of insolvency as a public perception. You don't have the same loss of goodwill equally, I think. Depends, of course, on the way it's done and the way it's reported and the way it's approached, but I think CVAs, certainly from a public perspective, are perceived as more of an indicator of a business in trouble than a scheme of arrangement tends to be. Also, the important practical point is you don't trigger then your insolvency related clauses in any contracts, which can be crucial and is often a key reason to choose between CVA or a scheme or some other process. Similarly, again, to CVAs, directors remain in charge and the company continues trading all the way through the process, and then obviously comes out the other side, and you don't have that supervision, which you then have to have in the CVA. So it's a slightly more independent process, and again reflects the fact that it's not an Insolvency Act process. And I think it also is a more immediate, or can be certainly a more immediate effect. So in Sunbird, for instance, we were dealing with a debt for equity swap and a round of fundraising, and once that came into force, that's it. It's done. Your debt's equity, and once you've got the rights issue underway, you're good to go, and you've achieved what you set out to achieve. That's one particular example, but you can envisage that there will be many different ways of achieving that through a scheme. And then the other thing to bear in mind is that it's you can use it for non-COMI companies. It's a different test. So it's not the COMI test, it's the sufficient connection to England and Wales test, which is a slightly less onerous test, so may be relevant if you're dealing with cross-border matters. So why not schemes? They are more expensive than CVAs. And that's because they're complex, they're process heavy, as you'll have kind of gleaned from that quick run through. There are a lot of court hearings, you have to put a lot into the documentation. Additionally, it's worth being quite careful about understanding where your opposition is going to come from, because in almost all circumstances, you will have to meet the company will have to meet any opposing creditors' costs of attendance and representations at the hearing, even if they're not successful in their opposition, because the court takes the view that creditors should have the chance to air any concerns, and as long as the representations are clear and focused, and assist the court, which they typically will be, then the company will be liable to pay them, even if the scheme is sanctioned. So again, a consideration which I think should always be taken into account in deciding on whether to go down the scheme route is to bear in mind that the cost can and will escalate extremely quickly if you've got opposing creditors involved and you have to have kind of days of hearings, which is what it can run to. There's no statutory moratorium, another downside. So you've got a risk of parallel action being taken by creditors, and obviously that then defeats the object. Now, in practice, if you've presented a winding up petition and then a scheme is proposed, you can imagine that the registrars, the ICC judges, are extremely unlikely, very hesitant to wind up a company that's in the process of proposing a scheme, because, of course, again, one of the tests that's going to be applied by the court in deciding whether to sanction and by the creditors in deciding whether to vote in favour is whether you're going to get a better outcome in a scheme than in a liquidation. So the winding up court won't preempt that. They will typically allow the scheme to unfold, and then if the scheme is approved, the winding up petition will be dismissed in any event as part of the approval of the scheme. The other thing to note is, unlike a CVA, you do have to have that additional layer of court scrutiny and approval, because there is a very significant ability by virtue of schemes to bind dissenting minorities. So they can be, that can be time consuming. As I said, it can be very expensive, but also it can just be fatal for the scheme. And you shouldn't assume that it's just going to be waved through. Although if you do things right and properly, and your scheme is well formulated and can't be subject to any major criticism, then that shouldn't be a reason not to use them.
Great, and back to me. So I'm going to be talking to you on restructuring plans now, and these are essentially a new restructuring process that was introduced by the Corporate Insolvency and Governance Act 2020. It is closely modelled on schemes of arrangement, but there are in fact a few key differences which I'm just going to bring you through so you should be aware of. The first is the trigger. And this is which I on the slide I've referred to as the financial difficulties threshold and purpose requirement. Under Part 26A of the Companies Act, these new restructuring plans are only going to be available to companies that have encountered or are likely to encounter financial difficulties, likely to affect their ability to carry on business as a going concern. And the purpose of the plan must be to essentially avoid that or ameliorate that. And I think the point to note is that this is potentially much broader than the insolvency concept of an inability to pay its debts. In the first sort of one of these that kind of was used in the Virgin Atlantic case, the court noted that there is a broad definition here, and the legislative intent is to allow plans to be used in a restructuring context. And therefore, I think it'd be very surprising if going forward, the court sought to interpret the financial difficulty threshold and the purpose requirement in a very narrow way. I think the idea of a restructuring plan is to allow access to it sort of kind of as an antecedent to the company getting into real difficulty. So if you see that there are problems on the horizon, there's now this very fancy, new, modern way of seeking to restructure a company with all its bells and whistles. So the second main factor, main difference, is that is an economic interest factor. So what a company that is seeking to implement a restructuring plan can do is it can apply to court to disenfranchise a class of creditors or members from voting on it if they can show that the class has no genuine economic interest. So that's obviously a very useful tool. Under schemes, creditors with no economic interest can be excluded, but they cannot be bound by it. So unless there's a residual claims mechanism has to be put in place for them. Under Section 901C, subsection 4 of Companies Act Part 26A, there's specific references to this disapplication, but it doesn't go on to state that a class will be bound by the plan. So that does suggest that they can in fact be bound, and the plan can deal with their residual claims. It's likely that someone's going to try this at some point in the future, and the courts are going to have to tackle this head on. But it would be surprising if essentially a restructuring plan, this statutory basis, is intended to be an exact mirror of the old common law positions, and not in fact have more sort of powerful means of affecting company rescues. I think that'll be an interesting one to see how that plays out in the courts. The third is the sort of the voting threshold requirement. So it's a 75% by value of the relevant creditor's debt or members' shares to pass one of these plans. So unlike in a scheme, though, there's no need for an additional there's no additional requirement that there needs to be a majority by number of those voting to approve it. So essentially, as time has gone on, that sort of numerosity showing that greater than 50% of those voting in number have approved was very hard to justify, where obviously you're dealing with people's or creditors' sort of economic interests. And actually, this was seen as a move to bring the UK in line with other jurisdictions and to help create this sort of new process. The fourth change or distinguishing factor is the cross-class cram down. This is a new concept essentially into UK restructuring law. In essence, it means that the court can sanction that a class of creditors or members, including senior or secured creditors, can actually be bound by the scheme against their will, essentially. So effectively, a dissenting class of voters cannot block the plan if the court is satisfied that none of them would be worse off under a relevant alternative, and then at least 75% of the value of a class of creditors or members which would receive a payment or of a genuine economic interest have voted in favour of the plan. So this is a really useful tool for companies that are facing holdout creditors. So previously under schemes and things like that, you'd have the risk of a class of creditors effectively being able to veto your plan. Whereas what you can do now is with sufficient consent, sort of take over their interests, put into a plan into place that prevents the holdout. Interestingly, as I said, it doesn't appear that the provisions prevent a dissenting senior class of creditors being crammed down by a junior class. That may be difficult in practice because senior creditors will remain free to enforce their security, and the plan itself doesn't carry a moratorium. But obviously, in the right circumstances, that this may be an option, and is obviously a very powerful tool. Other key features to be aware of the restructuring plan is that it includes a special category of moratorium creditors if a moratorium was entered pre-plan, who may be able to veto the plan's application to them. I think the main point to really take away is that a plan operates in a similar way to the way schemes do, and nor is it intended that plans are going to oust schemes of arrangement. The financial difficulty conditions mean solvent companies will still need to look to schemes to implement their sort of corporate shareholder transactions when they want to restructure. In terms of how it's working in practice, it seems to be working okay. Obviously, the first big case was the Virgin Atlantic plan, and since Virgin Atlantic is still alive, well, we can say that it's a bit of success. There's obviously huge room for complex argument over cross-class cram downs. There's going to be, at some point, a case where there's going to be a lot of fighting over the valuations, a comparison of the relevant alternatives, such as administration, liquidation, or in fact, an alternative plan. That being said, the first instance of this being used was pretty smooth. That's the Deep Ocean 1 case. And it was, in that case, it was clear that the dissenting class would be better off under the plan than under the relevant alternative. And the remainder of the creditors had actually overwhelmingly supported the plan. So this is a process that is being used, and it's being used pretty quickly after it's been introduced. It's, I think, a very modern and pragmatic development in the UK's restructuring arsenal, and will likely become more popular over time because of some of those weighty features that it has in order to bind creditors, despite them sort of piping up and saying, we don't want this. But yeah, there we go. That's the restructuring plan.
Great. And then finally, we're almost there. We will come back to some questions quickly. I think we'll have a few minutes. The CIGA moratorium. New, similarly to the Part 26A process, new process introduced by CIGA 2020, which was intended to give financially distressed companies some breathing space for enforcement action. So something of a knee-jerk response, I think it's fair to say, but a relatively sensible one, giving short time to companies to sort themselves out effectively without the threat of immediate enforcement action. Again, new to us in that it's a debtor in possession process. So the directors are left in control to implement restructuring during the moratorium. There is an independent monitor who's an IP, but they don't have the same level of oversight as you would have in the case of a supervisor, for instance. The company is protected from enforcement in respect of pre-moratorium debts, but has to continue to pay its moratorium debts in full throughout. Creditors can't wind the company up or start admins, no forfeiture, no security enforced, no repossession of goods or property, and you can't start or continue any legal process. So it's a relatively wide-reaching stay on any enforcement or any legal processes at all. Initially lasts for 20 business days. You can extend it for up to a year with creditor consent or by order of the court for longer. Query whether that's likely to happen. Partly query whether that's likely to happen because these are quite uncommon, as I'll come on to at present. So who's eligible and how do you go about it? It's got to be the company's directors that propose the moratorium. The company has to confirm, or directors rather have to confirm, that the company is or is likely to become unable to pay its debts. Now, we don't know exactly what that means, but we assume that it's either cash flow or balance sheet basis. But kind of conflictingly, it has to be able to continue to pay certain debts, so namely those that arise during the moratoriums. That's the monitor's remuneration, any wages of employees, any redundancy payments, which of course may have arisen as a result of the past 18 months or so as they fall due. And it's also got to be certified by the monitor, the directors, that the company is likely to be capable of being rescued as a going concern because of the moratorium protections. The process is either out of court or court order on an application. You have to use the court process where there's an outstanding winding up petition, but you can use the out of court process in other circumstances, specifically where no moratorium, CVA or admin has been in place for the previous 12 months. Should say that there is a relaxed condition on that in that respect for anything pre-September 21. Similarly with the winding up and stat demand stuff, that has been extended on a number of occasions. So how well does it work? Very hard to say. Classic lawyer's answer. There were four, I'm told, between June and December 2020. So not widely used, I think it's fair to say. But I think we can expect to see more and more of them as we get back to landlord enforcement, repossessions, winding up petitions. Obviously, the now relatively lengthy stay effectively on all of those processes is, we now think, coming to an end. So I think that being the case, you're much more likely to need that immediate protection from those kinds of enforcement processes, which I think makes using the CIGA moratorium a bit more likely. They are a creature of COVID. It's an odd, as I said, it's a slightly odd thing that you have to say that you're kind of unable to pay your debts, but also you're able to pay your debts. Obviously, you can see that there are plenty of circumstances where that would arise, but we're sort of still getting to grips with how that functions in practice. It's also worth advising your clients that unless they're actually sort of pretty far along the process of imagining or developing whatever restructuring plan they're going to put in place, then this is unlikely to help them. It's 20 or 40 days in almost all circumstances, subject to extensions. So unless all your creditors are on board and you know you've got some breathing room, or you're, as I say, you're pretty far along the process, not probably worth bothering with. As I say, there's lots of advantages to them, obviously, in as much as they have pretty wide-reaching assisting methods, I suppose, for companies, to give breathing room, basically. It's also worth noting that it doesn't trigger the 127 void transactions provisions, so another way in which they're really useful. But as I say, they're more likely to be of use where you've kind of already got your restructuring plan in place, but because of now the increasing pressure which is likely to be coming from landlords and creditors generally, as far as the end of the winding up stay or effective stay goes, then it may be that additional time is just needed, that being the case. Otherwise, unlikely to be that helpful. So I'm going to run through just a few very general points, and then we'll try to answer a couple of questions very quickly. The earlier the better. I know this is an obvious point, but and to an extent not something you can control, because typically your clients will be coming to you when the winding up petition is either presented or is threatened. But it's much better to do it before that and without the pressure of that in the background, because obviously that is effectively a ticking time bomb for businesses. Important to liaise directly with and make sure that key creditors are on board, because basically whichever route we've taken, as you'll have seen, you've got a threshold, and so your restructuring plan is highly likely to succeed if you haven't got those key creditor consents and they're not on board with whatever you're proposing. And that links into the next point, which is that sometimes clients aren't always that keen to sort of be as thorough as possible. It's massively to their advantage to be as thorough as possible. This is kind of, you know, their one opportunity in many cases to get it right, to include everything they need to include. Because the last thing you want is to discover that there are debts that have not been included within whatever's proposed, subject to whichever process you're dealing with. And so effectively the scheme hasn't worked. So important to be as thorough and detailed as possible. It's not a cheap or straightforward process, restructuring, but obviously the corollary of that is that it can save a business in trouble. And be realistic. The failed CVAs I'm referring to as retail CVAs, but over 50%. It's around that mark, but around or over 50% of retail CVAs fail. So it's worth being realistic at an early stage. You know, obviously for many, they'll just want to give it a go because it's kind of a last chance. And particularly where there's money to be paid into the CVA on an ongoing basis, you can't really predict whether they're going to be able to do that. But they should be realistic about the prospects, because otherwise they've introduced vast sums of money in some cases and end up with nothing to show for it. And then make sure the time is right. It comes back to the earlier the better, but the moratorium is such a valuable tool that arises out of restructuring processes. So make sure the processes are ready to go, the proposals are ready to go, whatever it might be, so that the company properly benefits from the moratorium. James, there's a couple of questions that I think we can answer quite quickly. So shall we give those a go? A couple of people have asked who can be appointed as an LPA receiver. The answer is anyone. It doesn't have to be an IP. Often it is an IP, but doesn't have.
And I think in practice, you're really going to probably want an IP, because they're most likely going to have the experience relevant to going into a business, taking the assets and knowing how to sell it.
Yeah, absolutely. Yeah, so, having someone without just sort of charging in and doing all sorts of silly
I mean,
things.
I always want to see that happen, because I think it would be pretty funny. But I think, you know, it's probably best to avoid disaster where possible.
Agreed. I think that's
there's a question regarding qualifying floating charges.
Yeah.
Running through the importance of them and what qualifies for what. I think the importance of them essentially is that they enable you to basically put a company into administration. It was sort of the quid pro quo of getting rid of or at least moving away from administrative receivership, still allow those creditors that have security, that have the security over generally the whole or substantially the whole of the company's property, and therefore have slightly greater security interest than maybe other creditors, a means of trying to put the company into administration if that's within their interests. In terms of what qualifies the qualifying floating charge, paragraph 14 of Schedule B1, it has to sort of state that the paragraph applies to it. It purports to empower the holder to appoint an administrator, and that, you know, it's over the whole or substantially the whole of the company's property. It's a fairly straightforward section, and generally it's going to be reflected in market standard documentation for floating charges. So.
Yeah, and they're, I mean, as far as the importance goes, they're obviously very potent, or give very potent powers to their holders. So, you know, if you are one, you can appoint an administrator. It's a very useful thing to be able to do. So, and typically overtakes other processes. So, even after the presentation, for instance, of a winding up petition, very commonly there would have been the appointment of an administrator pursuant to a qualifying floating charge, and that's the end of the petition. So yeah, obviously gives very significant potent powers. I think the final one we'll do, and then if anybody does want to pick up on anything by email, please do feel free to contact, I'm sure, either of us with any questions. There was a question right at the start about CVAs, and I'm going to answer this because I do think that CVAs are the things that we're all going to see the most of. Can a secured creditor release its security to become unsecured for the purpose of voting on a CVA? I think the answer is technically yes, you probably could, but I can't really see why you would, because your security is almost untouchable in a CVA, and there are almost no circumstances in which there could be any effect on your security unless you consent to it. So in theory, yes, you can of course relinquish your security and vote as an unsecured creditor in a CVA, but because the provisions of a CVA are such, or that the operation of a CVA is such that while it binds unsecured creditors, it doesn't bind secured and preferential creditors, it will almost always, I think, always be more advantageous either to just keep hold of your security and continue to be able to enforce it, or to negotiate separately and discuss separately with whoever's proposing the CVA the way it's going to work effectively, and what the arrangement is going to be between the holder of the security and the company, because that's much more likely to result in an advantageous outcome for the charge holder or the security holder than simply giving up your security and going down the unsecured route, because you would have to be pretty confident in those circumstances that the CVA is going to be something that that you either can vote down, or that you want to proceed, but either way you're not going to have your security afterwards.
I'm just looking through, there's a question about the new rating coronavirus and director disqualification dissolved companies bill. That is a bill that was first published, I think, on the 12th of May this year, so only a short time ago. Essentially what that proposes to do is allow the Secretary of State to go after directors who were directors of companies that are now dissolved within 3 years of dissolution. The question is, should directors consider instead formal insolvency restructuring procedures in order to deal with company debts properly, as opposed to dissolving the company and or allowing it to be struck off? I think really what I'd say there is, first, wait to see what the final form of the Act is. Secondly, I think if there's a fear that a director may be liable to disqualification, I think, you know, there's going to have to be a very sort of careful consideration of strategy, right? Because director's disqualification is a very serious matter, and I think to the extent that the director thinks they can avoid that by going through an insolvency process, then maybe that might be, in that circumstance, the right thing to do. But really, if sort of you come to a situation where it looks like there's been behavior that would give rise to director disqualification proceedings, the fact is, under insolvency procedures, the insolvency practitioners can refer you to the Secretary of State for director disqualification proceedings anyway. So you may not in fact avoid them. But I think if there are questions to be had over, actually, we need to sort of deal with the debts properly, going through those formal routes might be able to sort of clear any sort of concerns up and avoid that. But I think, you know, it's a very fact dependent and very serious matter to find yourself dealing with.
Absolutely. On that happy note, I think probably that's all we've got time for. As I said, please do feel free to get in touch if there are any questions you have arising out of the talk or more generally. And I think the slides will be circulated as well, so you'll have those after the meeting. Thanks very much, everyone, for coming. We really appreciate your time, and hopefully see you all in real person, if we ever have any sun again, on our roof terrace for some drinks very soon.
Great. Thank you very much, everyone.